don't want him calling everyone.
We're going to do concur, not concurs first, and we'll start off with Senate Bill 20.
Senate Bill 20.
So Senate Bill 20, this is the bill on out-of-court statements by child witnesses. The difference between the Senate version and the House version were largely technical and stylistic. There was the difference between the word "the" and "and."
All right, if people could, in the audience could be a little bit quiet, we got to hear counsel, we got to vote. I don't think the senators can hear on the horseshoe, so thank you.
Senate Bill 20. So the difference was technical and stylistic. So it would be a motion to concur. The House amendments modify it to what the Senate accepted in the House version. On the Senate, this came out 47-0.
Yeah.
Move to
I mean,
concur.
nobody knew.
All right, the motion's to concur.
You don't need the phone?
Oh, you just put it in my office. Okay.
Is everyone okay concurring? All right.
Thank you.
Are you okay concurring? Is everyone okay? All right.
This is, the question is whether to recede or not recede. The House has requested that the Senate recede. This is the Safe Harbor Bill, House Bill 833.
They didn't concur?
They did not.
Not recede. They really shouldn't have done that on the last day of session, a bill that technical that we rewrote. That was not smart on the House's part.
Okay, so conference.
Not recede. That was, oh, I can't believe the House did that. I can and I can't.
Is it, their bill is still in the posture that the bill came over? Okay, no, not received.
All right. So the motion's been seconded. We'll appoint conferees.
Thank you.
Did you put on there?
I have the perpetual mic, it won't go.
Okay, let's go with House Bill 441.
So House Bill 441, this is the bill that requires Department of Public Safety and Correctional Services to notify BPD upon pretrial release of a defendant. It is not consistent in the posture that it's in with the Senate Bill SB 586, which was that bill that had the reporting requirements in Baltimore City as well as the jobs court. So you would amend this to be consistent with what you did in 586. Okay.
House School, that's it.
Well, they already amended it, or they already adopted that, yeah. So it would just be to conform to 586 for that provision.
Yep, is everyone fine with that? All right. So the bill passes unanimously favorable with amendments. We'll now go on to House Bill 437. And Jeff, we're just going to turn this into a
437. House Bill 437, as drafted, expands the application of 9501 of the criminal article, which is making false statements to law enforcement officers. Essentially, it clarifies that, or expands the prohibition, depending on how you're looking at it, to making a false statement to a public safety answering point. So that would be 911 call centers. And it sounds like the amendment is to amend the bill to be consistent with SB 881, which this committee in the Senate passed, which was a task force to study the practice known as swatting.
Same
Correct.
thing, yeah, same
So
thing.
it would be, right.
So I'd like to move the amendment. All right, so now the bill's before you is amended, so motions for favorable? Yeah. All right, second, everyone's recorded in the affirmative. Okay. Now, it's not on the list, we'll go to House Bill 34. Jamie, I'll give you a second to catch up, so.
So House Bill 34 codifies the prohibition on committing the common law crime of indecent exposure. For just that offense, the violator is guilty of a misdemeanor and subject to the existing penalty of up to 3 years imprisonment and a fine of up to $1,000. The bill also establishes a new offense by prohibiting a person from committing indecent exposure with prurient intent within the sight of a minor who is at least 2 years old and more than 4 years younger than the perpetrator. That offense carries a maximum misdemeanor penalty of up to 5 years and a fine of $10,000.
Regular indecent exposure, and then indecent exposure with prurient interest.
Right. Against that, if the minor is at least 2 and the age difference is
But
at least
regular
4.
indecent exposure doesn't require with prurient interest.
That's correct.
Right, okay.
Right,
First one you read is the current law on regular indecent exposure. The
Right.
second one is what the bill does.
right. But in order to do that, it needed to distinguish, so they just codified what was already existing and then added the new part.
Quick question. What's the, if you can, what's the difference between this bill and HB 185 and Senate Bill 326? HB 185? They're on a voting list.
So, HB 185 and Senate Bill 326, that is the visual surveillance with prurient intent. So that's somebody who actually surveils either with, a camera or
Gotcha.
just
Remember that, Judge?
keeping Tom.
Okay, got
Right.
you. And this is just for the,
That's right. I mean, it's somebody. Yeah, back to this bill. This includes 6-year-olds and 7-year-olds and 8-year-olds, because it's just more than 4 years old. At least 2 years, the victim's at least 2 years old, and the person exposing with a prurient interest has to be at least 4 years older than that person. So, I don't know. We are including 6-year-olds.
6-year-old have prurient intent?
I don't know, but that's just,
The question.
You established prurient intent for an 8-year-old?
Yeah, the question came up on the committee about what is prurient intent, and that's, I mean, it's more than just a general interest. It's sort of satisfying an urge or something like that, I think was what the case law basically said on it. So that may be a factor of consideration there. As far as how something would be handled, I mean, at some point you're looking at the juvenile court for jurisdiction. Well, that, I'd have to defer to Josh on that, yeah.
I feel like this bill is gonna put us in that spot where, and we've been dealing with that, the other cases with sexting and youth. I mean, with the point that you bring up is you could have a 7-year-old who's at least 4 years older than a 2-year-old, and they're prosecuted under this.
out loud to Mr. Prada, what was the ultimate, how did that boil down on juvenile court jurisdiction?
So the juvenile court with the JGRC bill that was just passed, they only have jurisdiction over a child at least 10 years old. So if you're under 10 years old, you can't be charged even with a delinquent act. So under the juvenile justice bill, the juvenile court only has jurisdiction over children at least 10 years old. So if you're under 10 years old, you can't be charged even in the juvenile court. For the crimes of violence.
Okay, 10 to 13, got you. Okay, right.
Move on table.
The fine, when there's a mens rea,
Yeah, it's
that's a
judge
pure
or state's attorney, right?
intent.
Are you sure you're not talking about, we're on 34.
Yeah.
Yeah, 34 is the indecent exposure. The other one is, I think the one that you're talking about, Senator, is
185?
185, yeah.
Oh, okay,
Okay.
I'm sorry.
We're on 185, HB
No,
185.
34.
House Bill 34 is indecent exposure in the sight of a minor. So a person who commits indecent exposure, generally under the bill, would be subject to the existing penalty of, it's 3 years and $1,000. But that person is subject to 5 years and $10,000 if the offense is committed with prurient interest and the victim is a minor who's at least 2 years old and more than 4 years younger than the perpetrator. So it's creating a,
That's exactly what I thought we were voting on.
Yeah.
Now,
right.
I'm good with that.
Yeah.
Yeah, I don't want, I'm not voting against that. I like that bill.
All right, so, you want to press your motion, or?
The concern that I have is, all right, so I think Mr. Prada said that DGS doesn't have jurisdiction for children under 10. The 4 years, with the 4-year-old, the more than 4 years younger than a person, so we have a 7 and 11 or a 7 and 12-year-old. Again, it-
10.
Well, let's say 13 because they have jurisdiction at 13.
Yeah.
Yeah.
I'm just wondering, I just have some concerns about how we've dealt with things before when we're dealing with juveniles and these types of sexual crimes. I mean, I get that you have to prove some mens rea or prurient intent. I just have some concern, some unreadiness.
Court, is that correct?
For the minor, no, I can't think of a reason why it would be.
Well, no, they have some non-felonies that are charged in adult court. I got you, but still. So is that your concern, Senator Sidnor, that you just don't want a kid charged like that's undressing in front of their younger sibling?
Good, Senator Hellman.
Thank you, Mr. Chairman. So I hear what you're saying, but I think the prurient intent is hard to pin on a child, and the larger issue among adults who are doing this to children is kind of the point of the bill that I think is the real problem we're trying to address here.
And in the past, when we've dealt with things like sexting, it was the adults that we were going after, but it's still children that were getting
Or
captured in
swept
this.
up, yeah.
Right. That's the only unreadiness that I have. I mean,
So-
I get it.
And I hear you, but for me, having the prurient intent linked to a kid is a big stretch. So I just don't see that happening in real.
Sidnor, did you want to like do an amendment for
I
an
don't think-
age? To have
I would, but I'm
adults?
just not certain with, because this is kind of on us this quickly, I'm not certain what the amendment would be. I don't mind getting the adult, I got that, and I agree with you, Cheryl.
You could say nobody over the age of 18.
Or what if you change person to adult?
Yeah. Sidnor has an amendment, I think, to change person to adult.
There you go. I like that.
Thanks, Shelley. Teamwork makes the dream work.
It probably kills the bill. Probably kills it.
Lord have mercy. Let it go and fix it next year?
I would.
I know we won't once it goes in. I like the amendment.
All right, so you gotta withdraw your motion.
Yes.
What's your amendment?
To say adult.
So he's pressing it.
That's fine.
So your amendment is to change more than 4 years old, strike that, then you're just gonna say an adult and an adult? Is that what you're doing?
It would,
Then do you have to change person on page 2, line 1?
let me see, an adult, let's see, exposure within the sight of a minor who is at least 2 years old and more than 4 years. That's it, I'm not certain how the amendment works. More than 4 years younger than the person, more than 4 years younger than the adult. Oh, no, that doesn't work neither. Line 3, page 2. I don't think that works either.
All right, let's go. We're gonna table this real quick, and Senator Sidner, you can think about how you wanna word your amendment, and we'll move on to, which, who has that? All right, so we're gonna go to House Bill 885, or is that a Senate bill?
It's House Bill.
House Bill 885, okay.
So House Bill 885, Howard County Sheriff Salary. This bill alters the salary of the sheriff for Howard County based on steps. So the way it would work out for 2022, it would be a salary of $113,000. And then beginning the next term of office, December 2022, it would be $148,138.
Because the House is holding a bunch of salary bills. Bills. Like, Frederick County sent 5 local bills over the House. I think like 2 are gonna come out. And it's not just me, other people. They're like killing other people's local bills. No, they're just stuck all over the place. I don't know. Well, the one's stuck on the floor. I told you with that one. That's the one that I was, yeah, they're in the same position I'm in.
Hold it if there isn't movement on their
All
side.
right.
I said it on mic, so, yeah. So these motions were favorable. Been seconded, everyone's, all right. All right, let's do House Bill 518.
So House Bill 518, Register of Wills maximum salary increase. It increases from $124,500 to $146,500. The maximum annual salary that the Board of Public Works may set for a Register of Wills. There is a cross-file that JPR passed, and it was identical. It was not unanimous on the floor. It was 42-3 on the Senate floor.
I don't know.
All right, motions for favorable. Okay. Is everyone okay? All right. All right. I'm gonna go to House Bill 650. All right, House Bill 650 though. Now.
Child support, arrears, workers' comp.
Hey, what about the, why didn't we move that?
Hold on.
Why didn't we move?
House Bill 650, that was you. Yeah, what does the bill do?
Too many. Yeah, so House Bill 650, execution on a judgment, child support arrearages, workers' compensation. So this bill amends a portion of the Courts and Judicial Proceedings article to authorize the Child Support Agency to execute a judgment on a claim for personal injury and workers' compensation insurance plans. The bill as amended would allow the CSA to collect a workers' compensation indemnity benefits, including any weekly benefits or settlement proceedings from a non-custodial parent for an arrearages.
It's my understanding that they can already attach to the workers' comp. This is to limit what they can take from the workers' comp claim.
25% roll. Yeah, so it's specifies that 25% of the net recovery by a debtor on a claims workers' compensation is
I'm not
subject
sure
to
why we want to do
execution.
that. I mean, if you're a deadbeat on your child support, why do we want to limit how much you can take out of the workers' comp recovery?
Exactly, because the person can't work because they are injured, and now they finally get some money, a percentage will go to the arrearage, but the rest of it has to go to the roof over the head, doesn't it?
This is accepting, you only get 25% can go to the child support. That's how I read this bill. I'm not sure why we want to limit that. That's what I thought the committee testimony was, the opposition. I don't know why we want to limit.
Favorable. They can catch up on their debt, pay their back rent. It makes sense that proportion goes to it, but not the whole thing.
Certain types of workers' compensation benefits subject to the bill, missing, however, settlements and stipulations that make up the significant portion paid in workers' compensation benefits. On the annual basis, they pay approximately $60 million in settlement benefits that wouldn't be subject to this.
Except for Mr. McAvoy.
Seconded, you want to do a roll call on it, or?
Motion's favorable.
Yeah.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yeah.
Senator Castley.
No.
Senator Castley.
No.
Senator Hillman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Which bill is that?
Chairman Smith.
Yes. Which bill is the, right, we go to House Bill 174. Senator Hedelman, you ready? All right.
So for some background for House Bill 174, so the LRCA is the Lead Rental Certification and Accreditation under Maryland Department of the Environment. So it's an online database that was created in 2021 to house data related to lead accreditation, certificates, and enforcement. The general public can use LRCA's public certificate search to find lead certificates for individual properties. So House Bill 174, going off of Senator Hedelman's amendment, which is the amendment ending in 121/1, it essentially strikes the entire bill, except for the changes made on page 6, lines 1 and 2, that says the information required under the specified subsection may be an issue of fact at trial during a failure to pay rent proceeding, and that citation cites to the requirement on page 3 of the bill that if a property is an affected property, a lead paint property, it needs to be registered appropriately.
That's different than the current law.
So currently, the property would need to be registered, but if it's not registered properly, you can't, as a defendant in a failure to pay rent, raise that as an issue of fact. Current law says it may not be raised. This bill says it may be raised.
I don't want to belabor this, but honestly, this is long overdue. When we first passed the first bill that required the registration, the intent was always that a landlord could not do this if they didn't have clean hands on the lead. So to me, this is long overdue and a necessary bill. I'd move favorable.
One other change, which was
Oh,
just to
yes.
change the effective date.
Yes,
Because-
sorry. So the effective date of the bill as drafted was January 1st, 2023. It was a request of some interested parties that it be delayed just to make sure that the system is working correctly. So that would give enough time. So it would be October 1st, 2023.
Okay, it's been moved.
Now the bill's before you is amended. Motions for favorable. Seconded. All right. Do you want to take up again, just real quick, just take up again House Bill 34?
Bells might be ringing.
Huh?
Yeah.
We just passed it. Yeah.
Fast around here.
All right. Got it. All right, let's just do 34 real quick. Senator Sidnor, you're okay? All right, then the motion is for favorable. Everyone's okay. All right, excellent. Now we'll pick up House Bill 185.
So House Bill 185 establishes that a violation of 3902 of the criminal article, which is visual surveillance with prurient intent through the use of a camera where the victim was a minor at the time of the offense and the person who conducted the visual surveillance was at least 4 years older than the victim, is a misdemeanor punishable by imprisonment for up to 5 years and/or a $2,500 maximum fine. The bill also adds a resident and another private place of private use or accommodation to the list of locations in the definition of a private place. One thing I do want to flag is that the way that it is listed out in the bill as far as that offense, I think it may have a constitutional issue with Apprendi. We kind of discussed that on the Senate version. But I do have an amendment that you guys had considered on the Senate version that would remedy that. No?
Favorable. Favorable on amendment. We ain't got time to stick a amendment on there.
You believe it's under 18 or it's
No,
under
it
18?
is.
It is, okay, thanks.
Yeah.
I'm sorry, we just passed it moving forward. Come on, let's get it.
Well, it sounds like they're not going with that one. is, yeah. So with Apprendi, anything that could affect the outcome of the sentence could raise the sentence. Any fact that makes the sentence higher is something that needs to go to the fact finder or the jury. So the way that this is spelled out is it just says that a person who violates this section by using a camera and, you know, also lays out that the element that it was against a minor and that the person conducting the visual surveillance was at least 4 years older is subject to the higher fine. So the way that it's laid out, that's in the bill's penalty provision that really should be its own prohibition. So that's the only thing about it.
Finder, then it's fine, right? As long as the jury decided it, or the judge makes a factual finding.
That would need to go into the jury instruction, is how I think they would remedy that even if the statute was written this way.
Yeah.
Yeah.
It's fine and they'll.
Well, we passed the bill on PBJs that. If we're all. Constitutional muster. This one's a lot easier.
Motion to conform to the House version? Senator Lee, you're good? Everyone's good? Recording the same vote? All right.